So hey folks, Dale Davidson here, Davidson Law Offices here in Georgia. Got a topic today that I'm going to answer this question. Why elderly parents should not give their homes to their children. So look, as we all age, we all start thinking about, hey, what are we going to do with all our stuff? How are we going to pass all our stuff down to our kids or grandkids? And so one common idea is to transfer the home to children before we pass away. We can either gift it to them or sell it to them at a pretty discounted price. Now, while this might seem like the loving and practical and right thing to do, it leads to a lot of unintended financial and legal consequences. And so I'm going to answer the question why elderly parents should think twice before giving their home to their children. Number one, you lose control and security. So once you transfer ownership of your home, it no longer belongs to you, right? That means your child, they could sell it, take out a loan, or if they face any kind of financial troubles such as bankruptcy or divorce, you could find yourself without a home. Even in the best relationships, life circumstances can change and you may no longer have the control you once did over your own home. Prime examples, several years ago, this guy, Peter, wanted his 98-year-old mother to move into a nursing home. Well, that's nice, Mom, move into a nursing home. Or you can come live with me. Well, she'd been living alone for practically all her life, probably. And so she says, no, I'm independent, I want to stay here. Well, this son went to court and served the mother with an eviction notice because, just before her 98th birthday, by the way, because she had previously deeded him the home. So look, she lost control. There's a lot, I mean, you just Google it, where a mother took her son to court over family property. Man transferred ownership of parents' home behind their back. So if you let or permit your children to, I want to say, touch the title of your house or your property, you run the risk of losing control and your security. So look, there's a right way and a wrong way to do it, but transferring your property to a child or grandchild during your lifetime is not the right way. Now, number two, potential family conflicts. There's nothing better than a family feud. Not really. They're terrible, okay? We have stopped taking family feud cases because they don't benefit anybody. But money and inheritance matters create serious family disputes. So if the home is transferred to one child and not to others, it causes resentment and tension among the siblings. Even if the intention is to keep the house in the family, that's okay. But there's no guarantee that your child will maintain the home or allow the other family members to access it. Prime example is, hey, got a beach house down at Cape San Blas, and I'm going to give it to my daughter because she's the one who lives closest and she would be using it the most, but she's got two brothers who live, 1,000 miles away or so. I'm going to let her determine when her brothers can use it. Boy, that's a nice argument to have with the brothers. So look, we always say when you have to share an inheritance, you don't really know somebody until you have to share an inheritance with them. And then they're going to be good or they're going to be bad. One of the two. So look, let's just try to avoid any kind of temptation by having one child be the recipient of property during your lifetime. Again, there's better ways to do that. So, because when you pass away, and that the inheritances are on the line, it's an unfortunate reality that we really have a lot of sibling rivalries out there, and the Hatfield and McCoys come out in a lot of people. So just be careful. Let's try to avoid family conflicts, because life is all about relationships, and let's avoid the conflicts. So number 3 reason why not to transfer your property to your child during your lifetime. There's Medicaid and long-term care consequences. Many elderly people need long-term care. In fact, the statistics say that 70% of us will at some point in time end up in a long-term care facility during our lifetimes. Okay, so either you're going to private pay or you're going to get on Medicaid. If you private pay, you can't have a whole lot of assets. In fact, your assets are limited to $2,000. You can have a house that's exempt, but when that Medicaid recipient passes, the state comes in and files a lien against the property. So that's not a good option, right? Well, that's why a lot of attorneys, a lot of people will say, well, let's just transfer the house to the child. Well, you can, but you got to do it in a specific way. Remember, Medicaid has a 5-year look-back period that says, look, if you transfer anything out to somebody other than your spouse, including your home, within 5 years of applying for Medicaid, then you're going to be penalized. Meaning, you're not going to be eligible for Medicaid because you made that transfer. Meaning, you're going to private pay. Okay, so this could leave you struggling to afford care when you need it the most. But look, there are right ways and wrong ways, and there are some exceptions to this rule. You just got to be careful about how you approach it. So, taxes. Nobody likes taxes. Our government doesn't spend our money wisely. We all know that. But when somebody passes away, there's tax issues for you and your estate, and also your children. So, if you gifted your home to your child during your lifetime, you create a tax burden for them down the line. If they decide to sell the home after receiving the gift, they didn't get the step up in basis, and we're going to talk about that in just a minute. But let me give you an example. You bought the house for $50,000. You gifted it to them. Their basis in the house is now $50,000. You die. They sell it for $100,000. So their taxable gain is $50,000. $100,000 minus the $50,000, which they'll pay a capital gains on 15 to 20%. Okay, that's if you gift the house to them during your lifetime. Now, if you wait and they inherit the house, then they get the benefit of a step up in basis, which means they paid no capital gains tax. Same example. You bought the house for $50,000. You die, the house is now worth $100,000. The kids sell the house for $100,000. No gain or loss. Your basis is now the $100,000, their fair market value on the date of death. But you're saying, well, Dale, how does that work with the Medicaid and all of that? Again, there are planning techniques out there and available that you could use to protect the home and at the same time preserving the step up in basis. But you just got to go see professional help. You really can't do that on your own. Okay? So, number 5, risk of financial hardship or lawsuits. So, you transfer your house into your child's name. It's their asset. If they go through a divorce, their spouse could have a claim against that house. Okay? Could be subject to equitable division. Depends on the state laws, all right? So, we don't want that to happen. You transfer your house. They have financial difficulties, creditors, whatever, could place liens on the house. You're still living in the house, but the house is in their name. And they get a judgment against them. The judgment attaches to all their real estate in the county, okay? So that's not a good solution. But the worst case scenario is the house might even be lost due to lawsuits, leaving you without a secure place to live. son or daughter, child, whoever it is, involved in a lawsuit, and they get a huge judgment against them. Now they've got a lien against your property, and the lien is foreclosed on, and you're out of the house. That would be a disaster. You know, there are always exceptions to the rules, or most always. So here are three better alternatives to gifting the home during your lifetime to a child. You can place your house into a revocable trust or a living trust. This allows you to maintain control. You're still secure in your home. I mean, it's still your property, okay? And then when you pass away, then there's a smooth transition to whoever you want to have the house, okay? There's no probate in a revocable trust or living trust. You could do a life estate deed. This allows you to live in the house for the rest of your life while guaranteeing ownership transfers to your child after your death. Now, there's a lot of, this is a two-edged sword to this, because for Medicaid purposes, that doesn't necessarily work, okay? So be careful with the use of this technique. Simply having a will, that's the basis of an estate plan. Leaving the home to your child or children ensures that they're going to inherit without any kind of tax penalties while you maintain control during your lifetime. Of course, this doesn't work very well if you are the recipient of Medicaid and the Medicaid files a estate recovery against your home after you pass. So folks, thank you for tuning in today. Like I said, while giving your home to your child seems like an act of love, it can have unintended legal, financial, and family problems. So be careful, okay? So hey, check out this video, Stop the Family Feuds, Proper Estate Planning Tips, for more information. Until next time, you have a blessed day.